right, so we're back on the record and we'll call the case of People v. Milligan. It's file 25-6995FH. Counsel, you want to state your appearances, please?
Melissa Kudush, Plain County Prosecutor.
And James Gilbert here on behalf of Ms. Milligan.
All right, Ms. Milligan is appearing from the Eaton County Jail by video, and Mr. Gilbert's had a chance to speak with her for purposes of the arraignment on the underlying charge. Have you had a chance to review the charging document with her?
We discussed the charging document, Your Honor, and she understands does not wish for it to be waived. I mean, to be read. Thank you. We waive the reading.
Okay, and how she wished to plead to the charge?
She'll stand mute.
Okay, quick courtroom decoder moment. When the defense says the defendant will stand mute, that's not courtroom drama for the cameras. It's actually a strategic legal move. Instead of entering a plea directly, the judge automatically enters a not guilty plea on the defendant's behalf. Translation. The defense is keeping every option on the table while buying time to assess the prosecution's case.
Okay, so we'll enter a plea of not guilty on her behalf to, it looks like, a possession of methamphetamine with a drug double enhancement. Is a forensic center referral requested?
It is not.
Estimated length of trial?
2 days.
Okay. Appropriate for docket call on June 9th.
I believe so, yes.
We'll do,
She does, Your Honor, have a pending absconding case in district court that I'm trying to get her arraigned on.
oh, okay.
I want to get them together. No,
Right,
Okay.
so I'm not sure if I'm gonna push that out further.
June 9th might be a little early if we're going to try to get the two cases together, Your Honor.
Oh, gotcha. Okay. Well, let's pick July 7. And we'll pick a nice round number for Eaton County. We'll do 2:30.
And right here you can see the behind-the-scenes chess match of criminal court scheduling. The attorneys are trying to line up multiple cases at once, which sounds boring, until you realize it can seriously affect plea negotiations, sentencing exposure, and even how juries perceive a defendant later on. Court calendars may not sound dramatic, but trust me, they quietly shape entire outcomes.
All right, so we'll schedule the docket call for July, say 7 at 2:30 in the afternoon. Allow Zoom appearances from the Eaton County Jail. We'll retain our Sheboygan County hold on that. So if Miss Milligan does, if she's released in Eaton County, she'd have to be brought up here, and then we can deal with that question at that point.
Your Honor, my office just informed me that Eaton County needs after 3 p.m. that day.
It's after 3. Well, let's do 3 p.m. 3 p.m. Okay. And also, Ms. Milligan, it's alleged that you're in contempt of court for failing to appear on your arraignment in this case back on April 15th, 2025. You have the right to have a hearing and proof beyond a reasonable doubt of your failure to appear and the right of the assistance of an attorney. You can be held in contempt for up to 93 days in jail or a $7,500 fine, and bond can be canceled.
Now this is where the stakes jump. The judge brings up the alleged failure to appear, basically accusing Miss Milligan of missing court, and in the legal world, judges take that personally. Why? Because the entire justice system depends on people actually showing up. Notice how the judge carefully explains the penalties and rights here. That's the court making sure the record is airtight in case this becomes an appeal issue later.
Which it has been. So you understand the rights that you have and the penalties that you face? Ms. Milligan, do you understand that?
Yes.
Okay. All right, Mr. Gilbert, no, not guilty plea as to that?
It is.
You enter a not guilty plea, and we'll schedule it for a status conference on that pending contempt at the same date and time. So, Ms. Milligan, what we're going to do is we're going to put this case, the methamphetamine case and failure to appear, out to July 7th at 3 p.m. By video from Eaton County. If Eaton releases you, you'll be up in Sheboygan, and then we can address any release questions at that point. And I'm told that there's a case pending in the district court. If that is bound over, then hopefully we'll have both cases tracking at the same time. Any questions for me, Ms. Milligan?
No.
Okay, you have a good day. And I've got this Young on video. That's 25-7086 FH up for a docket call and pending status conference on a bond issue. And Ms. Young is appearing by Zoom video. Counsel did inform me off the record that they're.
Did you catch that? The attorneys mention a possible resolution that could lead to dismissal. That's lawyers speak for. There may already be negotiations happening behind closed doors. And honestly, this is where a lot of criminal cases end, not with dramatic trials, but with deals, procedural fixes, or evidentiary problems the public never sees, makes you wonder. How many courtroom battles are decided before anyone steps in front of a jury?
Working on a resolution that might result in a dismissal here. Is that right, Ms. Goodrich?
Yeah.
So you want us to continue this matter then?
Yes, one more time. Ron.
Any objection, Mr. Gilbert?
No objection. Thank you very much.
We could continue this then to June 9th at 2:40 in the afternoon. And I'll allow Zoom appearances at that as well. If the matter is resolved, and you just want to submit a nollie, then I would also dismiss the pending contempt if that takes place. All right, anything further from the defense?
None for the defense. Thank you.
Anything further from the people?
No, no, thank you.
Okay, Ms. Young, you're all set today. Stay in touch with Mr. Gilbert, okay?
Thank you, Your Honor.
And that'll bring us to people v. Vanessa Williams. It's two files, 25-7111 and 7112.
If I could just have a moment with us,
Yeah. Do you want to talk with her in the jury room?
I can, because we have a new plea for her. I just like to go through it with
Okay. Do you want to do Mr. Case first?
If we could.
Can we situate her there for a minute, and then would the jury room work for a conference with Mr. Gilbert? So okay. Okay.
Yeah.
Okay. All right. So we'll pass that for a minute, and we'll call people v. Nathan Case 25-7061 FH, and he's scheduled for a docket call and a contempt sentencing that I think, have we been adjourning that contempt sentencing out? Okay. All right. And Mr. Gilbert, what's our status here in this matter?
We're gonna ask for a trial date, Your Honor.
Okay. And
Here comes one of the classic courtroom moments, the defense casually testing the waters for a bench trial. That means asking the judge to decide the case instead of a jury. Prosecutors often resist this because juries can sometimes be more emotionally persuasive, while judges tend to focus narrowly on legal standards and evidence. And judging by that little exchange, sounds like everyone in the room already knew the answer before the question was even asked.
given my previous comments, I don't imagine the prosecutor is going to consent to a bench trial.
No.
I was gonna ask.
All right, let's take down some information here. Let's see. What would be the estimated length of trial?
I would say a day.
I agree.
Okay. These one-day ones are. Ms. Goodrich, what about Thursday, July 23? No, the 16th, 17th, you said you weren't going to be available those days.
Also not on the 22nd and 23rd.
We've got Delaney scheduled on the 27th, 28th. You think that's a go, or could we use the 27th as this as a backup on that?
In July, Your Honor, I'm gonna be out of town.
Oh,
I'm
okay,
sorry.
well, that makes that move. How about Thursday, August 6th?
That works.
And there it is, trial date officially locked in, August 6th. This is the moment where everything suddenly becomes real. Discovery deadlines, witness prep, exhibit lists, jury strategy, the countdown clock starts now. And notice the judge's tone here, calm, procedural, almost routine, but for the defendant. This date could shape the next several years of their life. That contrast is one of the most surreal things about criminal court.
So we're going to schedule this for jury selection and trial on Thursday, August 6th. We'll begin as we commonly do at 9, but I'll want to see counsel in chambers say quarter till. Jury instructions and verdict form not less than 7 days before. We'll give you 21 days to file witness and exhibit list if that hasn't already happened. Bond will continue. We'll just continue the status conference, or no, we'll just continue the contempt sentencing continued to docket call date. Should we have one more docket call before the trial, just so we know, or if there's any pretrial issues, or do you just want to leave it and not do that?
I guess it's up to you. I don't see any pretrial issues.
Yeah, I think that if we need a court date, we could probably work it out
Okay.
in.
All right, we'll just continue the contempt sentencing to the trial date, and then we'll see what happens with that. I won't schedule a further docket call then. If anything changes, just let the court know, or if there's a motion that either side needs to file, just get with the assignment clerk to notice it up. So, Mr. Case, the next time that we'll see you is for your trial on Thursday, August 6th, unless something changes then. Okay, you have any questions for me, sir?
No, sir.
Okay, we'll see you then.
Thank you very much.
All right, let's go off the record.